Hi, I'm Mark Schroeder, the head of client relations at GSHC Surrogacy Agency, and today we're speaking to Casey O'Connell, an attorney at the law offices of Falletta and Klein. Casey, how are you doing today?
I'm great, thanks for having me.
First question, Casey, what is a pre-birth order and when is it established?
Great question. So under California law, when two parties enter into a surrogacy contract, that's kind of the first phase of the arrangement. The next phase, once the surrogate becomes pregnant, is to go to court and ask the court to declare the intended parents the legal parents of the child or children the surrogate is carrying. So the end result of that court process is what we call a pre-birth order or a pre-birth judgment. And more specifically, what that judgment states is that the intended parent or parents are the legal parents of the child now, that the surrogate and the surrogate's partner or spouse are not the parents of the child, and that some other details about who's responsible for the child's healthcare expenses and how to prepare the child's birth certificate as well. So all that's included in the judgment or pre-birth order. And then as far as when that's established, our goal as a firm, and we strive with our clients to begin that process around the 15th to 18th week of gestation. Typically, we have the judgment entered by the court before birth, just depending on the pregnancy, of course, but that's usually entered around the 25th to 28th week of gestation. So that judgment's in hand when the surrogate goes to the hospital to deliver.
And how long does that PBO process take on average?
So depending on when we start, because we're not always provided information when we would want it, so we don't hear about a pregnancy sometimes until a little bit later, but when we have the information, we request answers to questionnaires from our clients, from the IVF physician and from the surrogate's attorney and the surrogate. So when we get that information, then we draft the judgment documents. We send those out to the parties. Once they're returned to us signed, we file them with the court, and then we wait for the court to process and enter the judgment. There's no hearing that needs to be attended. There's no proactive steps that need to be done once that's filed with the court. We just have to wait. And typically the entire duration of that information gathering, preparation of documents, and filing and waiting is 2 to 3 months. So it's not an overnight process, and it can go quicker if parties return the documents to us quicker. And but that's on average about the time it takes. And right now it's a little bit delayed as well because courts are operating with minimal staff because of the virus. So some of the judgments are being delayed. So it's a time-sensitive process, but it does take a bit of time.
Can a PBO be established after the delivery of the child?
Yes, under California law, both before and after we can obtain that judgment. So as you can imagine, pregnancies can be quite unpredictable. Most of them are straightforward and go full term, and we have the judgment in hand before the baby's born. But we do have those cases where children are born prematurely, and that judgment might be pending with the court at the time. So we can go to court and obtain that either before or after the birth of the child.
And for international intended parents, how can they establish parental rights in their home country?
So that's a difficult question to answer in one response because every home country is different. What happens here in America is they're declared under the laws of the United States to be the legal parents of the child. Now, depending on where they're returning to, they then have to register their child, so to speak, in their home country, their country of residence or citizenship. So each country is different, but from our understanding and the needs that go along with the judgment they'll obtain from a court in California or wherever their surrogate may give birth, they take that back and then complete some paperwork with their home country. We recommend that they speak to an attorney in their home country well in advance of this to plan for what will be needed. But it's as simple as returning home and then just meeting with the authorities that govern that process in your home country. But obviously there are certain countries that are a little bit more difficult, and some planning needs to be done depending on certain factors such as the status of the relationship, whether you're married or not, the composition of the relationship, whether it's same-sex or heterosexual, and then also the genetic makeup of the child. So all those factors come into play depending on what your home country is.
Can same-sex international couples both be listed on the birth certificate of their child?
Again, very dependent on the home country. So for example, in Italy, the original birth certificate for a same-sex male couple cannot have two fathers on that birth certificate under the current laws and from what I understand. So we usually obtain a birth certificate with just one father and then ask for the authority to amend that birth certificate later to reflect both fathers. So again, it's very dependent on the home country.
I'm Mark Schroeder, and this has been a conversation with Casey O'Connell from the law offices of Falletta and Klein. Casey, thank you so much for your time today.
Thanks, Mark. Anytime. And if your clients ever have any questions, feel free to reach out. We're happy to help.